What if I told you that you can get a car for free legally using consumer law? What if I told you that when a bank denies you an auto loan, they might actually be breaking the law? The truth is, banks don't lend money the way you think they do. Your signature actually creates the credit, meaning they aren't using their own money. So, how can they legally deny you? And if they do approve you, guess what? They still aren't lending you anything. They are monetizing your promissory note, getting paid up front, and then making you pay again. Today, I'm going to be exposing how banks manipulate auto loans, how to fight back against denials, and how to legally challenge your car loan using consumer law to get a vehicle without paying out of pocket. First things first, thank you guys for watching this video. If you're brand new, make sure to like, comment, and subscribe because we are going to be dropping some bangers today, okay? I'm going to be dropping some key information on how to be able to challenge these auto loans and challenge these banking institutions that lie to us, okay? So make sure that you are investing in me because if you invest in me, I'll invest in you. Now, I've been studying these things for almost 3 years now. And we're pretty much at a point right now where now we're on a consistent basis dropping content for you guys, giving you guys the game completely free, and nobody wants to talk about this. Everybody wants you to, they're going to give you little bits and pieces on how to be able to challenge these things. They're not going to give you the full story. They're just going to give you the result and tell you how you can do this, right? But they won't tell you inherently what you are supposed to do and how to be able to challenge if it doesn't go perfect how you want it to go. Now, the biggest lie when it comes to car loans is that banks don't actually lend money. Instead, when you apply for a car loan, your signature actually creates the credit, okay? And here's the key point. Since you fund the transaction with your promissory note or promissory note, I know you guys butcher me in the comments, the bank doesn't use their own money. So if they're not using their own money, they cannot deny you. It's actually would be illegal for them to deny you for a loan that they did not even create. You dig me? So we'll talk about why banks essentially will deny you even when they shouldn't. But before I talk about that, let's talk a little bit about some of these laws that kind of back up this information I'm about to talk about, because these are the laws that you can utilize to either challenge via written form, or you can try to be able to kick some of this game to the dealers or the finance managers, or even or if you're able to get on the phone with the underwriter. To be honest, I'll talk about this, but it's a proper way to do this. A lot of these laws I'm going to talk about, do not scream this at the salesperson. The salesperson doesn't know what you're talking about, okay? So first things first, we can talk about the Federal Reserve Act, Section 16, where it pretty much breaks down the fractional banking system, also under 12 U.S.C. 411, issuance to reserve banks, nature of obligation and redemption. It talks about the whole Federal Reserve system and essentially says that under this subsection is that Federal Reserve notes are obligations of the United States, not the banks themselves, okay? Number two, the banks do not actually lend money or lend actual money. Instead, they create credit through ledger entries, and this is also expressed under modern money mechanics, which we'll talk about in a second. Your promissory notes, quote unquote, loan agreement is converted into an asset which the bank then uses to generate credit. So essentially what this means is that the bank doesn't loan you pre-existing money. They create funds based on your signature and ledger entries, all right? And this is how fractional banking works. Your loan becomes a financial asset that the banks profit from. So furthermore, if this becomes a financial asset that banks profit from, this goes hand in hand with my mortgage video. This goes hand in hand with my rent video, okay? This goes hand in hand with my loan denial videos because, and we'll talk about the loan denial laws and such. But if this is something that you guys profit from, you guys are now double dipping, okay? Then we go to the Federal Reserve Act, Section 16, where it pretty much breaks down what is also discussed in the modern money mechanics. In the modern money mechanics, it says that, this is a quote from the modern money mechanics, when banks make loans, they create money. A bank simply credits the borrower's account with the deposit of the size of the loan, and the bank does not take this money from anyone else's account. It is created out of thin air. All right, I'll pull that up. It says here, right here on Google, that this statement is true. When banks make loans, they essentially create new money by crediting the borrower's account, effectively adding to the money supply, not taking it from anyone else's account. It talks about fractional reserve banking. Okay. It talks about money creation through accounting. Okay. It also says key points, not printing money. Okay. So people will say, oh man, they are printing money. They're not printing nothing. Dig me? So furthermore, under 12 CFR Part 204, it expresses that banks operate under a fractional reserve system, meaning they only need to hold a small percentage of deposits and can create credit through ledger entries. Okay? Depository institutions. You dig me? And there's no legal requirements for banks to use actual deposits to issue loans. Okay? So they don't have to give you any real money in order to give you a loan. We can also go to UCC 3-104, which essentially defines a negotiable instrument as a signed document that promises to pay a sum of money. So if you sign a promissory note, that is a document that you sign that you promise to pay a certain amount of money. So if you understand the UCC and you understand what a negotiable instrument is, then this is something that you can express as well. Also, under 3-105, it means that issue means the first delivery of an instrument by the maker or drawer. Okay. And long story short, it states that a negotiable instrument is treated as money once it is signed. Okay. Because it becomes a financial asset, this is something that they use to monetize your loan. If they sell your loan, they are not a holder in due course anymore. So they cannot enforce the loan. Okay, so if the bank sells or securitizes your loan, they may lose the right to enforce it. Okay, so again, if your bank sells to a investor, okay, and gets paid up front, then they no longer hold the original note, and they may not even have legal standing to collect payments from you. Okay, so again, you challenge them, and we'll talk about how to properly challenge them. But under the holder in due course rule, 3-305, it protects you against people who do not have holder in due course, and it forces them to provide proof that they are the holder in due course. Under 15 U.S.C. 1601 essentially is the Truth in Lending Act. Under the Truth in Lending Act, they must disclose any and everything about the loan. Okay, they must provide a full disclosure of the credit terms, including how the loans are even funded. Okay, so if the lender fails to disclose that your promissory note created the funds, they may be violating consumer protection laws. And if they violate the consumer protection laws or even lie about anything in regards to something, then you can essentially challenge them under 15 U.S.C. 1611. Okay, where they'll be under criminal liability for willful and knowing violation. Okay, go back, it's under the Truth in Lending Act. Okay, they will be under criminal liability. Dig me? So they cannot lie about this, they cannot disclose that they loan you money, and they cannot disclose that they do not loan money. They have to disclose where they're getting the funds from. Okay, and if they lie and say, oh, we got the funds from ourselves, then they'll be under criminal liability. Okay, so now the loan denial becomes illegal if the bank is not actually loaning credit. It's not giving you actual credit, cash in hand. Now the loan becomes illegal, okay? Because the creditor must provide a legitimate reason for denying credit. And if the bank is not actually lending you money, then their denial may be legally questionable, okay? So if the bank is claiming they're denying you based on risk, but they never lend their own money, they may be violating the Equal Opportunity Act under 15 U.S.C. 1691. Okay, which is the scope of prohibition law, which is connected with the Equal Opportunity Act, Equal Credit Opportunity Act. And so essentially, when they try to challenge you and say, oh, you wasn't credit worthiness or you wasn't credit worthy, if you guys don't actually lend or risk anything, they cannot deny you based on my credit worthiness. Okay, and also at the same time, the bank must provide full consideration under contract law, meaning that both parties must bring something of value. Okay, so if the bank never provided actual money, but instead used their signature to create credit, then there is no valid contract. Okay, so if you guys don't risk or provide anything, then you may not have legal standing to collect on the debt. Okay? So if banks don't lend money, they monetize your signature. Okay? And your promissory note becomes the actual credit that funds the loan, and they aren't using their own money, how can they legally deny you based on creditworthiness? And if they fail to disclose how your loan was actually funded, they may be violating the Truth in Lending Act. Okay? So let's talk about how you're going to be able to fight back against the bullshit that these creditors do. So they'll use credit scores as an excuse. Okay? But your signature is real money. Many denials are pre-programmed based on internal policies. So yes, they're going to deny you. Okay, but you can challenge them on whether they're taking risk or not. Okay, and if a bank denies you without full disclosure, this is according to 15 U.S.C. 1691, then essentially you can tell them to pretty much provide the disclosures as to the reason why they denied you. And so then we could talk about 15 U.S.C. 1692, which is essentially the advertisement of down payments, where they cannot advertise a down payment when it comes to consumer credit. Okay? So they cannot ask for a down payment unless credit is actually extended. Okay? So if a dealership advertises financing options but denies you or asks for a higher down payment, they may be violating the law. Okay? Now, if they deny you after advertising financing, you can file a complaint for deceptive lending practices. Okay, the whole challenge is you want to challenge them on their deception. Okay, so how to use this against the banks or dealership. If they advertise 0% down or guaranteed approval but deny you, challenge them under 15 USC 1662. Okay, advertising down payments and installments. Demand that they provide a full explanation as to why you were denied. And if they violated this law, you may have legal grounds to challenge their financing practices. So when you ask them to provide that written documentation, they're going to put in there, oh, we denied you because they can't put that in there. Okay? They can't put, oh, we denied you because you didn't want to put down a down payment, because they'll be legally liable. Okay? If you're not giving me actual credit, why are you denying me? Okay, so how to essentially fight back when you get in a position where they are denying you for a car loan that you're supposed to get. Okay, so number one, you want to demand a written explanation under 15 U.S.C. 1691, the Equal Credit Opportunity Act. Under the ECOA 15 U.S.C. 1691, lenders must provide a reason for denial within 30 days. Okay, now a lot of you guys will say, well, expect those things up front, but sometimes they're going to say, hey, we're going to send you a letter about this. Okay, you can have a conversation, you can talk to these to communicate and try to get from the finance manager to the finance manager to the underwriter to the banking institution. You can try to get to them there, but many dealerships to banks won't let you get to that point. So you have to be willing to put these things in writing so that you can request these things in writing. Okay, and also at the same time, you want to have record of this. So if they fail to do this, they are in violation of the federal law. If you can show that, hey, I reached out to you guys and asked you guys to prove your denial to me, then yeah, you are in violation of the federal law. Okay, number two, you want to request proof that the banks actually loaned you money. Okay, so you want to send a QWR, which is a qualified written request, demanding that the lender provides proof that the lender used their own money for the loan. 2, evidence that the loan was not securitized or sold. And 3, a full breakdown on how the loan was funded. You want to be very specific to be prolific. You want to be very specific in order to get these answers, so that when you show up in court with this evidence and documentation that, hey, look, I asked them for this specific information and they did not provide it to me, or they lied to me. Again, we're talking about criminal violation for knowing and willful violation. Okay? So if they cannot provide this proof, they will not have legal standing to deny you of credit. Okay. Number 3, you want to file a complaint with the CFPB and the state attorney general if the bank or dealership engaged in deceptive lending practices. Report them to the CFPB, report them to the FTC, report them to your state attorneys general. Now, I'm not going to sit here and say that this is going to make things, guarantee a result or a resolution, but this can get the fact that, hey, look, I'm challenging on these things and I'm willing to CC these people on what you guys have done. I'm willing to take more action than just screaming to you and telling you that you are wrong. I'm going to record you, and yeah, once I pull out the recording, you're going to act like you don't know what I'm talking about. Nah, I'm going to send you an actual legal writing for these things. And according to the Truth in Lending Act, according to the Fair Debt Collection Practices Act, according to even the mailbox rule, and also under the UCC, when you send a letter, a contract is formed for them to perform. You dig me? And provide whatever it is that they're asking for in regards to the Truth in Lending Act, the UCC, things in that nature. Okay, so essentially you want to do this if you get denied. Okay, you can try to have this discussion with them over the phone. You can try to bring up all of these laws as to why they don't loan you money or lend you money. But if you look at the Truth in Lending Act and you challenge them based on the Truth in Lending Act, okay, you challenge them based on the Equal Opportunity Act, and you challenge them and you provide or you ask them for a qualified written, or you send them a qualified written request, and demand these things, or even better yet, if you tell them, hey, I'm going to send a letter for this, yes, they'll probably wait on it. Okay. And that's the thing. Be prepared for them to say, okay, yeah, no, we're not going to follow your directions over the phone, because technically this phone call is not legal. I can say whatever I can or want to you over this phone. Okay. Now, let's just say you get approved. Now, this is, in my opinion, the best way to get a car for free. Okay. The best way to get a car for free is to, challenge them is to discharge the auto loan. Okay. After you have gone through the aspect of getting approved, you actually have better negotiation power with the 700 plus credit score when you get approved, because if you get approved, now you can just you can get your vehicle. You don't have to really waste time, fight for your vehicle and things in that nature. But if you get approved for the vehicle first, now you can start to challenge them on the same laws that I just talked about under the Truth in Lending Act. You can challenge them under the UCC laws, or you can challenge them under the FDCPA. So first things first, you want to use the Truth in Lending Act to rescind the auto loan. You have a right within 72 hours to rescind the auto loan. Okay, some states even have 30 days. Now, under the Truth in Lending Act, the lenders must disclose all terms of the loan, including how your credit created the transaction. So if I just discussed that your signature creates the money, they must disclose that to you. Number 2, if they fail to disclose how your signature funded the loan, you may have the right to rescind the contract, meaning now you guys have participated in deceptive lending practices. You just voided out this contract by participating in fraud, making me think that you loaned me money. Okay, and if you guys didn't disclose this information to me, yeah, you cannot collect on this debt, and I'm going to rescind this contract. Step 2, you want to challenge the loans using UCC laws. So under UCC 3-305, you can essentially challenge the loan if the bank is not the holder in due course. So back to the fact that if your bank was sold or securitized, they may not have legal standing to collect payments. Okay, so if they sold your loan or used it as a financial asset, then now you guys cannot double dip on the money that I just gave to you. Okay. Step 3, you want to demand the original promissory notes, okay? Under UCC 3-501, okay? You can force the lender to produce the original note, okay? If they cannot provide the original wet ink signature note, they may not have legal claim to collect on the debt. Now, what is a legal wet signature? Meaning that it has to be the original thing that you signed. It cannot be a photocopy, because a photocopy is bullshit. You dig me? Anybody can produce that. Okay? Now, what to do if they try to repossess the car after you have done these things? You have to make sure to do these things in order for you to get them to not repossess the vehicle. Okay? Step 1, if they try to repossess the car, you want to send them a debt validation letter under 15 U.S.C. 1692G. So that means that when you have done everything prior to the approval and you have sent them a letter to challenge how they funded the transaction, you sent them a letter to rescind the loan, you challenge them under the holder in due course law, and then you demand the original promissory note, and they did not provide it or provided you a photocopy, which was not the answer to what you asked for. Now they try to do something like, oh, we're going to repossess the vehicle. Before they repossess the vehicle, they must give you a 30-day notice. So when that 30-day notice comes around, you want to send them a debt validation letter under 15 U.S.C. 1692G. You want to do this prior to you getting your first bill, okay? Under 15 U.S.C. 1692G, repo companies must prove that they have a legal right to take the vehicle. And if they cannot validate the debt, they cannot legally repossess the vehicle. You want to do this because if you do this, this will keep them from repossessing the vehicle. They must dispute your debt before they repossess the vehicle. And if they say, oh, this, that, and the third, and they, again, to you are demanding the original promissory note, and you have record of you doing that, and they still do not provide the original promissory note in order to validate the debt, then they cannot repossess your vehicle, okay? Because now it becomes a debt battle. If they repossess your vehicle, it is unlawful. Okay, so if they denied your credit improperly or refuse to honor your consumer protection laws, they can be sued for damages. So this is why it's important for you to make sure you have things in writing and you send these things in writing, because if you send these things in writing, then you have evidence to pull up in court for unlawful repossession and literally sue them and kill them. Okay, kill them in court, unalive them in court. Okay, all right. Now, number 3, you can challenge the assignment of the loan under UCC 3-305. If the loan was sold or transferred without proper legal standing, the repossession may be fraudulent. Okay, so these are some of the things that you pretty much are redoing that goes hand in hand with any other loan, any other debt. Okay, a lot of people think that it's something different, but it is the same exact thing that you can challenge them on, the same way you can challenge any debt collector on these things. You can challenge an auto loan company on these things as well. If they approve you, you can discharge the loan. If they denied you, they may have violated the federal law. Either way, you have power. It doesn't matter if they approve you or deny you, you have power to be able to exercise your right and potentially get your vehicle, get your loan, or be able to discharge the loan or rescind the loan. Okay? So after all of this, if we understand that there are laws put in place to challenge them, there are laws put in place to prove that your signature creates credit for the purchase. Okay, there are laws that enforce that the bank sells your loan as a security and gets paid up front, and there are laws that enforces the fact that they'll try to make you pay monthly even after collecting more money than they're supposed to. How they are getting paid twice. The bank itself gets paid twice and try to double dip. There are so many ways that you can challenge to get a free car, okay? And it's not as easy as people say to believe. It's not that you'll just walk into a dealership and recite these laws to them. It's good to know these laws, because if you do know these laws, maybe you can be able to persuade the dealer that you're talking to at least escalate you to the right person. Okay, let me speak to the finance manager. After you speak to the finance manager and you disclose these informations to them, the finance manager says, okay, well, bet. All right, I hear what you're saying. Let's just go ahead and move forward with this, okay? Because we're going to make money regardless, and that's the whole point, for us to make money, okay? Now, if the finance manager wants to play this hating thing, okay, bet. Then you need to go straight to the bank. You want to talk to the bank's finance manager. You want to talk to the banks, okay? And potentially try to get it escalated to the underwriter. If you get on the phone with these people and they're giving you a hard time, let them know that you're going to send them a letter asking them for these things. Try to get this stuff expedited. Try to rush this stuff to them. Send it certified, okay? So that you get a receipt that they have got and received your letter. Okay, if it doesn't work over the phone, be willing to send them a letter after the fact. Be willing to battle them in court for these things, okay? If you're not ready to battle them in court for these things, or you're not ready to write a letter, if you're not ready to learn these laws yourself, if you're not ready to even challenge them or even go to distance, it's no point of you even doing this. I'll keep it a buck with you. A lot of people think that they're gonna go based on hope, but you have to truly know and understand and trust that when you go in there with this information that you're gonna walk out there with a vehicle, okay? I always tell people you're in a better position if you are a 700 credit score, you get approved. If you get approved, then now you can start to go after the discharge on the back end, okay? If you go on the discharge on the back end, now you can play more of an offensive role than the defensive role, okay? That's the whole key, okay? A lot of us, think it's a game of, I'm gonna walk in there and they're just gonna give me a car. Sometimes you may have to leave and try the next dealership. Sometimes these things may take 1 day, 2 days, and sometimes this stuff may take 30 days, maybe even 60 days, maybe even 90 days, because they have 30 days to respond, okay? But if you know the law and you're willing to go the distance, okay, you can be able to get your car for free. It's not as easy as soon as you do it, as soon as you send that one letter, your car is completely free. If they send you a bill, you have to be willing to send them a letter questioning them on the bill, challenging them, asking them for the validation of the debt, asking them if they have a true premise to even come after you for the debt. When they try to repossess your vehicle, do not ignore the letter and say, oh, well, they're not supposed to according to the law. No, you need to send them a letter back telling them that they cannot do that and to prove their legal standing for being able to do that. Prove that they're the holder in due course. Prove that they haven't securitized or made money up front. Prove that your signature didn't create the money. You have a right to ask them for these things and for them to disclose this information to you, but you have to do it properly, okay? So if you guys got to the end of the video, comment the word discharge. You dig me? If you got all the way to the end, I know that you're a real one. All right. Secondly, down below, I have to complete that guide. It's only 47 bucks. Go ahead and tap in. Okay. I break down the administrative process and how to communicate with debt collectors. Also, all of my YouTube videos in regards to debt discharge, loans, things of that nature are also in there, more packaged together so that you guys can be able to know which videos are expressing what. Number 2, join my one-on-one mentorship. Okay. Down below, you can click to apply to my mentorship. Okay. Now, my mentorship particularly focuses on being able to help you fix your credit, get funding, and also be able to monetize yourself, okay? Be able to turn that credit into wealth, turn that credit into cash, okay? So if that's something you're looking to do, only for people that are serious about building wealth, not just people who are just trying to discharge debt, because sadly, if you have debt to be discharged, I wouldn't tell you to apply for my mentorship. I would tell you to get the complete debt guide. It's only 47 bucks. Why would I want to sit here and you try to join my mentorship? And it's a premium service, so it's not something that you should do if you have debt, okay? If you have debt, get the complete debt guide, learn how to do it properly. It's only 47 bucks. You do that and then be able to shoot me DMs and things in that nature. Also at the same time, I made a video yesterday on Solo Suit. Solo Suit is a platform where you're going to be able to challenge debt or try to do the full debt validation process, and they'll do it for you using AI technology. That link will also be in the description. And also follow me on Instagram at biz.nick. Okay, I post daily content from motivational, financial literacy content, consumer law content, debt discharge content. And if you want to be able to tap with me on a consistent basis, make sure you follow me on Instagram. Once again, thank you guys for watching this video. I love you guys. Like, comment, and subscribe. Put down below exactly what else you want to learn. For those of you guys that made it to the end, comment the word discharge. I love you guys, and I'll see you in the next one.